As I always say now, good whenever this is. And I don't know what time it is. But anyway, not legal advice. Please like, subscribe, share with your friends, relatives, plants, and animals. Uh, Today, I'm going to try to touch briefly on three topics. One, a petition that was filed recently in New York regarding MMTLP and MMAT. Two, another amicus brief, that's a friend of the court brief, that was filed in the Alpine case. And three, Elon Musk's view on the SEC and their protection of retail. And this is directed at Mr. Musk, since he just did an interview that I'll address at the end of this particular video. Uh, I am a member of many retail traders that have been impacted similarly to the way you state that you've been impacted. And we would love if you reached out to us, because we certainly would like to support you, and you obviously would provide us a lot of support. So please reach out to any member of our community. There's a lot to reach out to. If it's me, that's great. But if there's plenty others, so please do so. We would welcome it. Before I get into the other topics, and I'll go back to that at the end, three quickies. I'm feeling pretty proud of myself today. Um, the puzzle that I bought said 3 to 5 years on the side, but I finished it in only 23 months. Never date an apostrophe. They are super possessive. And last but not least, my math teacher called me average. How mean. So moving on to the New York petition. So that was a petition that was filed in New York State Court under the New York statutory system by Steamroller, which is an LLC entity, a Florida LLC. So that's a particular form of a entity. There's corporations or limited liability companies, or you could be individual, etc. There's partnerships, etc. So a limited liability company is just a form of an entity, and usually there's individual members, and there may be there probably will be a managing member, and that might be a company or individual. And all those members are asserted, and I only read the petition. I didn't have a chance to read the points and authorities that go with it. So often when you file documents with the court, you may file uh, a memorandum that has legal citations, and that might include legal argument. And separate and apart from that, you might also file something called either an affidavit or a declaration, which is a statement of the facts under penalty of perjury. So those are kind of different, because the declaration has to be factual. The points and authorities and is argument, and so it's different. Doesn't have to be necessarily factual. You could use the facts to make arguments. So I've only seen the petition. I haven't seen all the documents, but in essence, this particular entity, uh, they own apparently the dividend from MMAT that was issued, that turned out to be eventually the MMTLP shares that are now the NextBridge shares. And the argument is that back in or about September, October of 2021, there were some market makers and brokers that fraudulently got this dividend to trade. And nobody can figure out who these people are, because nobody's talking and nobody has access to the information. So in the petition and in the action that will be following, they went after the OTC markets, because the OTC markets apparently has that information. So the petition asks the court to order the OTC markets to disclose the names of those market makers and hedge funds and whoever else was involved in or about October 2021, who submitted that, because they must have a fraudulent Form 211 or other forms, because nobody authorized it, etc. So that's the basic position, that there was fraud in getting it to trade in the first place. And it, per the New York statute, there's not a similar statute in California. it can be used to identify the defendants. And I think this particular case, and I don't know anything, by the way, about New York law, so I'm just talking. And obviously, you shouldn't rely upon any of this stuff. Um, but I compare this to the prior petition where they were seeking, I think, the names of 105 brokers versus this much narrower petition where they're just seeking the names of a few, I think, few market makers or brokers who help trade. I just think it's a more compelling argument, this petition, than the other one. And I think that other petition right now is on appeal, also in that same state court. I don't know if this is before the same judge, but even if it's before the same judge, I happen to think this petition, at least my view, not knowing anything, not knowing any of the facts, any of the real facts, I just think this has a more compelling ring to it that somebody committed fraud to get it to trade, and we need the information. And obviously, if so, let's assume the court grants that and orders the OTC to give that information. Perhaps they will. Hopefully, they will. That might prove to be very valuable to not only MMTLP, but MMAT. And who knows, based upon what comes out of that, it might help a whole bunch of other tickers that are fighting the same battle. So it'll be interesting to see. I think the action was filed in the last 3 or 4 days. There'll be a period of time. I'm sure there will be briefs filed by the OTC, and eventually there'll be a hearing. And I'm sure you will hear the results. And obviously, if I can add anything to it, I will. So, but that brings up to up to speed as to this petition. It may yield really interesting evidence, and obviously I think Mark Bazile's firm is handling it. Wishing them the best and success for all of us. So that's one. And again, that's in the state court of New York. There's no such statute that exists in California, or else I'd be doing the same thing. There's a few states that have that, and but I think Mark has tried this a few times, and this now has more experience on this kind of weird fact pattern. So hopefully, we get a positive result, and I'm sure Mark will do his utmost to get us that result. So, moving on. Alpine. Alpine GTII, we all know the connection. Alpine's a prime broker, GTII of GTII. We believe there's lots of bad shorts. Bermuda shorts. Those are the naked shorts, but I'm going to call them the Bermuda shorts. Counterfeit, because who wears Bermuda? Doesn't even exist anymore. So let's call the counterfeit shorts Bermuda. So we know that there's tons of Bermuda shorts, and obviously there's a dispute now involving an injunction, denial of an injunction in the federal court, and that's on appeal. And a bunch of parties have filed briefs. A bunch of people and entities have filed briefs. The parties themselves also filed briefs. So the parties are the named people in the dispute. Some non-named people have also filed briefs, and as I indicated, those are called the Friends of the Court briefs. And there have been a number of them, more than you would see typically in any case. And again, this is not on the final decision. This is just an injunction. So I think it's somewhat odd, but I understand why. And the latest one, so I think I've gone through each one. The latest one was brought by, I think her name is Carrie Devereaux. She filed it late yesterday, and then she filed something else today. And I think somebody asked me a question about who could file amicus briefs. And as long as you get approval from the court, I think anybody could file it. And that's what happened with this particular one. She's not a lawyer, so that's quite an effort to get something filed in an appellate court. She, and I think it's a she by Carrie being a C, being that first name spelled with C. She apparently had a prior run-in with FINRA in terms of an arbitration. Apparently, there was some kind of company, Bennett Capital, in or about 2010, that apparently did some type of Ponzi scheme. I don't know any of this, by the way, firsthand. And the writer of this brief ended up in dispute with FINRA, and it was a FINRA arbitration, and she lost the arbitration and had to pay some money, and then it was affirmed on appeal. Then on top of that, she sued a bunch of judges, and I don't know the success of that, but she sounds pretty dissatisfied with the outcome of her um, involvement with the FINRA and the SEC. Now, this particular arbitration, I think, happened in 2010, but she still fervently, maybe a little too fervently, uh, against the regulatory system. So she just showed up to argue that despite Alpine being, and she didn't mention this part, despite Alpine being complete scumbags, as I've referenced on many occasions, objectively speaking, she thought that FINRA is basically a cartel and they screw retail. Now, some of that I agree with, that they screw retail, but um, I think part of it also is sour grapes because she lost and she feels like she shouldn't have lost. And so, therefore, she's presenting her support for Alpine. The only argument she did make that I think is a legal argument was she made the argument about the appointments clause, and that's an argument that's been made on behalf of Alpine. The appointments clause being there's a constitutional argument that if there's some judicial appointments in this case that need to be either appointed or confirmed by the executive branch. And here the FINRA hearing officers should be. So the argument is that if the executive branch didn't appoint them or confirm them, then, and here FINRA appointed and confirmed them, then that would not be a proper judge to hear matters, and it would be unconstitutional. That's her sole constitutional argument. That's fine. The rest more is just a tirade against FINRA and the SEC, and even though I agree with it, I don't know how much it would be considered by the court, to be quite honest. So that was filed late yesterday, and another document today, and so that's that. She also indicated and just summarized, which I found was interesting, and I checked so far. And when I go through each brief, this one was only from her. I may only give you the first name of the party that filed it, but there might be multiple people that filed these amicus briefs. And she indicated, and I checked, there were, I think, 38 parties that are filed briefs on behalf of FINRA to this point in time in support of their position. And as you know, I just think that this is an easy, if I were the appellate court, I would toss Alpine out on this particular fact situation. I don't think they deserve an injunction. They may have other arguments later on, but at this point in time, I would. So the appeal is from the denial of the injunction from the district court. If I were the appellate court, I would sustain the denial. In other words, I would agree with the lower court, and I would throw Alpine out on their nose and let them try something else. But I wouldn't give them the time of day. And we'll see how that goes. And we'll see what the other parties do. That doesn't say, by the way, that I support FINRA or the system, because I don't. But I don't think Alpine should be the spokesperson for the good neighbor and good business practices. I think the Supreme Court should wait for a better party before acting upon FINRA. And and I think I mentioned before, there are other cases. There's another case on appeal before the same. I think in Florida, I believe. No, excuse me, in D.C., and it's on appeal. The Kim case, I think, similar issue, but Kim is a nicer guy than Alpine, so he might get a better shake. It also tests the sufficiency of FINRA's judicial system. All right, that I did, and I'll obviously keep you apprised as that goes on. Last but not least, I saw the interview involving Elon Musk and Lex Friedman. Lex Friedman does these great interviews, and one discussion was about the SEC and regulators and how they, were difficult on Tesla and Musk, and he called it regulatory capture. His theory, and just so you understand, if you look at our, you could check, But if you look at our videos, being mine and JR's videos and our live streams, we've talked many times that there has to be the regulatory and the capital markets have to be distinct, and there cannot be somebody who works in the regulatory system and then 6 months later works at Goldman Sachs. It just doesn't work. Now, I suggested a 4 or 5 year time difference. So if you worked at the SEC, for example, you couldn't go work in the regulatory markets for, let's say, 5 years. You know, it could be more or less, but there has to be a sufficient gap so that people aren't negatively influenced by potential opportunities later. And that's exactly what Elon said in his little pitch. He said, most of the SEC lawyers weren't making very much money. So they were looking for trophies. And when they would get a trophy, like a good case, and they could catch somebody, they would then use that to get a job at a hedge fund where they could make a lot of money. And that was what kind of carried the day. And they had no concern or interest in retail. And that's why nothing gets done. So again, to Elon, we agree with you. And we would love to have you as a partner. We could provide you a ton of support, and we know that you would provide us a lot of support. And you agree with the same opinion, and you've been suffering from the same malady and symptoms that were certainly engendered by the conduct of FINRA and the SEC. So I found it interesting, the comments, saw it today, and it is kind of what we've been talking about. So Elon, we are on the same team. Anyway, to all you out there, we will see you Sunday night at 8 p.m. Eastern, Three Lawyers. Everybody have a great Friday evening or weekend. Be well. Take care. Goodbye.